All right. So the big news broke yesterday. That Disney is suing for full control of certain Avengers characters like Iron Man, Spider-Man, Doctor Strange, Ant-Man, Hawkeye, Black Widow, Falcon, and others. This comes as a result of certain heirs of late comic book creators, such as Stan Lee, Steve Ditko, and Gene Colan. Their heirs are trying to seek. It's okay. I'll just read what it says. The suits seek declaratory relief that these blockbuster characters are ineligible for copyright termination as works made for hire. If Marvel loses, Disney would have to share ownership of the characters worth billions. Essentially, this doesn't mean much. It sounds scary, like, hey, the heirs of Stan Lee and Steve Ditko and all these wonderful, amazing creators can reclaim the rights to these characters, which means what? Essentially, it just means that Disney will have to pay them money to use their characters. It's not, at least from what I've read through multiple outlets and everything, it's not like, hey, we're going to seize control of these characters again, and then we can say, nope, Disney, Marvel, we don't want you to use our characters anymore. Please stop. We own these characters, blah, blah, blah. It's really just, hey, we're the children of people, or the family of people who created these characters, and you're using them, and we would like to receive money for that. That is supported under the 1909 copyright law, saying that heirs or relations of inventors or creators who have things copyrighted, those people can claim financial benefits from use of those characters as they own the rights to them. Disney is asserting, no. You don't own the rights. The Steve Ditko, Stan Lee don't own the rights. The people who own the rights for these characters is Marvel. Disney bought Marvel. We own the rights to these characters now, because they were created by Stan Lee and Steve Ditko and others only as a result of being hired by Marvel as freelance writers and creators. And that's what Disney, that's what their lawsuit is saying. And where it goes, essentially, we'll have to wait and see. This article does point out as well previous cases that were litigated, wherein that standard was upheld, where the standard of, these are people who are hired by Marvel as freelancers, and they don't get to claim the rights to these characters. You can't copyright claim a character that was created for someone else or for their publishings, and the original creators were paid on a per page basis for their contributions in their work. So that's essentially where this is at. I'll go on. I'll read some more of this. So in August, the administrator of Ditko's estate filed a notice of termination on Spider-Man, which first appeared in comic book form in 1962 under the termination provisions of copyright law. Authors or their heirs can reclaim rights once granted to the publishers after waiting a statutory set period of time. That's what I was talking about, the 1909 copyright law. According to the termination notice, Marvel would have to give up Ditko's rights to its iconic character in June 2023. Marvel was facing other termination notices. For example, Larry Lieber, who worked at Marvel as a writer too, filed termination notices over creations in May. The heirs of the comic book creators, including Black Widow creator Don Rico, are being represented by Mark Toberoff, who once famously represented Superman creators Jerry Siegel and Joe Shuster in an unsuccessful termination attempt against DC. They say it was unsuccessful, but at the same time, anything that Superman appears in, you see them credited. I don't know if that necessarily means that they're profiting off of it, but or their heirs are profiting off of it, but they certainly get their credits. DC saved off termination by counterclaiming against Oberoff and asserting notorious in the interference of its rights. The publisher was presented by Dan Petrocelli at O'Melveny, who just so happens to be representing Disney now in its effort to keep rights of various Avengers characters. Petrocelli is filing several lawsuits in New York and California against Lieber, Don Heck, Patrick Ditko, Don Rico, and Keith Detweiler. The cases will focus on the creation of famous comic book characters and who should be deemed the statutory author. The litigation figures to focus on the Marvel method, a loose collaborative working atmosphere where initial ideas were briefly discussed with artists responsible for taking care of the details. The Marvel method has been the subject of prior litigation, such as a dispute a decade back over Ghost Rider. It will again, for example, one of the complaints filed today asserts Marvel had the right to exercise creative control over Lieber's contribution and paid Lieber a per-page rate for his work. Yeah, that's what I was talking about earlier. So, essentially, this is the claim that Disney is making, that these people already paid for their contributions and were hired to do this for Marvel, so that they're not the actual quote-unquote owners. Toberoff has a lot of experience doing this type of case. Almost a decade ago, he represented the estate of comic book legend Jack Kirby over whether he could terminate a copyright grant on Spider-Man, X-Men, The Incredible Hulk, and The Mighty Thor. In August 2013, the Second Circuit Court of Appeals affirmed a lower court's ruling that determined Kirby's heirs couldn't wrest back his share of rights to these characters because the former Marvel freelancer had contributed his materials as a work made for hire. So there is legal precedence already on this, which is why Disney thinks they can do this and get, reclaim the rights. The Kirby case was then petitioned up to the Supreme Court, with the late Ruth Bader Ginsburg signaling some interest in taking up the case. Marvel at the time fought hard against any high court review, and before the justice decided, the case was settled, which means they settled out of court. Even then, it probably wouldn't, in my opinion, it probably wouldn't have got brought up at the Supreme Court. And even if it was, they might also send it back to what the Second Court of Appeals decided. That's usually how the Supreme Court works. Anyway, now comes new litigation, which figures to pick up where earlier ones left off. Marvel's suits called the latest controversy virtually identical circumstances to Kirby's. If the plaintiffs win, Disney expects to at least hold on to at least a share of character rights as co-owners. The studio would have to share profits with the others. Additionally, the termination provisions of copyright law only apply in the U.S., allowing Disney to continue to profit and control from foreign exploitation. Clarified that Disney is only facing the loss of full ownership. So it does. Do we as fans of the MCU have anything to fear? Do we have to be concerned about Marvel losing the rights to these characters? Does this mean that all of a sudden, once if the rights are reclaimed back by the heirs, that Disney and Marvel have no control, no say over anything with the characters? I don't think we have to be afraid of that, to be honest. What I do think is, if it comes down to it, it'll be settled again out of court, and Disney will end up having to just pay for the use of these characters in future films and other things. And we have to understand as well, like, there are multiple revenues where rights are important. Like Fox for the longest time had rights to X-Men and Ghost Rider and other characters, and then Marvel bought those rights back. There's TV rights, there's movie rights, there's distribution rights, there's publishing rights. There's so many different kinds of rights. So I don't fully understand exactly which rights are being sued for, and I'm guessing it has to be the movies, to be honest. But ultimately, what will happen, in my opinion, is it'll be settled out of court. I guess the other aspect to this is, are the heirs being greedy, or is Disney being greedy? Because ultimately, this is all over money. And the real question is, right, well, does Disney have the right to sue? Obviously, that's a yes. Is it ethical for them to do it? Is it such a big deal to pay the heirs of creators over this, or are they right? Is it like, well, we bought Marvel. We spent $4 billion or whatever it is to buy Marvel. We own these rights. We in Marvel paid for these characters to be made. They the people who made them were paid for their work, and now Marvel owns the rights to those characters, and Disney bought Marvel, so Disney now owns the rights to those characters. Or do you think, no, Disney's just being greedy? They have, creators should be paid for their work, and their heirs, based on the 1909 copyright law, should protect that. I can see both arguments. I don't know who's right or who's wrong. I think that none of that is actually that interesting or important. The most interesting part of it is well, what does it mean for the future of the MCU, right? And honestly, based on what I've read and my understanding of everything, it kind of just means nothing. This is all over money, and it won't affect the ability of Disney to use these characters in future films or whatever. It'll just impact their money, really, like their wallets. And that's really, I think, where it's at. So I think there's a big deal being made about this in some aspects, but I also think it doesn't make much difference. I'm not very concerned about it, and I think that ultimately nothing will come of it other than Disney will pay the heirs when they use the characters, and it won't be very much. I don't think it'll be very much. I think Ed Brubaker had something similar happen. He created Winter Soldier, and he's like, hey, Disney uses Winter Soldier, and they barely pay me shit. I don't make much money off of that. Like when they use my characters, I don't get much money. So it'll be something like that. But I think if you do create a character, right? Like if you created Spider-Man, you should hope to make a lot of money from that, especially because of how important Spider-Man is to Marvel and how big of a character he is. Like, sure, you should get the money. After you die, should your kids continue to profit from that? According to copyright laws, yes, if it was owned by the person who created it. But if it's owned by Marvel because he created it for Marvel, well, that's a whole different thing, right? So, and maybe in some ways it's like Marvel's scummy for the way they did that and like how they own characters that other people created. But at the same time, it's like that's smart business on their part. And this is probably something that like Disney should have been aware of or looked into heavily before or during the process of purchasing Marvel, because if you're gonna buy the rights, buy a company pretty much and get the rights to all these things, you got to make sure that they actually own the rights properly, right? So yeah, I think that's about it. I don't really have much else to say. I just wanted to do a short little thing to go over this because I like talking about weird things like this. So hopefully I cleared some of the stuff for anybody who was wondering, and everyone have a fantastic day. Much love. Goodbye. Peace out.